CIT appeals. So basically, friends, today's topic is kept with the intention that in the faceless era, whether you want or not, but many times it will happen that your case will travel to CIT appeals. And now, as per the proposed amendment, CIT appeals is going to be a faceless. So it is very important for us to learn all the nitty-gritties of filing, drafting, replies to the CIT appeals, because it is a quasi-judicial authority. And in that situation, we have to quote different honorable courts cases to prove our arguments. So for that, as per the AGFTC's Young Tax Professional Drive, we have invited an honorable faculty, Advocate Jaimin Gandhi, who is practicing taxation in high courts, tribunals, and on CIT appeals level. We welcome you, Honorable Sir. So with this, I request President of Income Tax Bar Association, Sri Dhruvin Bhai, to give his brief speech.
Thank you, Karthikeya. First of all, I welcome all the members of IT Bar and AGFTC, and also welcome to our eminent speaker. Today's our speaker, eminent speaker, Advocate Jaimin Gandhi, will brief us about the appeal before CIT appeal. CIT appeal is the first appellate authority which can be approached against the order passed by the AO. In old scenario, we have a different kind of practice and to file the return for scrutiny and even for the appeals. But after getting online everything, our working style is totally different now than before. Now we do not need to go to the cabin and explain everything orally to the officer. Now in the faceless scenario, we have to submit everything in written to online. So we need to understand more accurate. We need to be more accurate while giving submission. Which point should be added, how much in brief, which point should be in shortened way, which cover important things which we need to explain to the officers. So now we need to understand how, what, when, how much details to be submitted to the officers. So our today's speaker, our expert speaker, will guide us in how to file the appeals and what things to be, what needs to be care, needs to be care for these. So I welcome you again, sir. Once again, thank you.
Thank you, Dhruvin Bhai. As today's honorable faculty, Jaimin is also a very good friend of mine, and we have studied together. So I take this opportunity to introduce Advocate Jaimin Gandhi. Mr. Jaimin Gandhi is practicing as advocate before the Honorable Gujarat High Court and various subordinate courts in all fields of law. He is qualified chartered accountant. He started his practice in association with Sri Saurabh Bhai Soparkar, senior advocate in 2008. He regularly appeared before the Honorable Income Tax Appellate Tribunal in association with Sri Saurabh Soparkar from 2008 to 2012. He was appointed as Assistant Government Pleader in 2012. He served as Assistant Government Pleader representing the state of Gujarat before the Honorable Gujarat High Court in various civil cases from 2012 to 2015. He was associated with Sri Vimal Patel, advocate and solicitor. He has served as standing counsel for the Department of CGST, Excise, Customs, and Service Tax from 2006 to 2020. Friends, today's faculty has a lot of experience from the counsel side and from the independent advocate professional side. So we really appreciate his selfless service to contribute his expert knowledge to all our members. And with this brief speech, I invite our honorable faculty to give his expert speech. Thank you.
Good afternoon, seniors and friends, and thank you AGFTC and Mr. Karthikeya Shah for providing me this wonderful opportunity. I start our today's topic regarding issues pertaining to appeals before the Commissioner of Income Tax Appeal. I first take up the three basic issues which are regularly being faced by the advocates and chartered accountants appearing before the CIT appeals, namely regarding additional ground filed before the CIT appeal, fresh claim made before the CIT appeal, and additional evidence is filed before the CIT appeal. Though as such, these are procedural provisions, but if we fail to adhere to the statutory procedural provisions, it can at times become very expensive in high-stake litigations. I start with the first topic regarding additional ground before the CIT appeals. Additional ground before the CIT appeal is, so to say, an omission in the original appeal memo filed before CIT appeal. Let us take an example. If the assessing officer makes additions or disallowances on 5 grounds, and at the time of filing the appeal before the CIT appeals, if for whatever reason, as CA or advocate, you file appeal only on 4 grounds, the 5th ground is either omitted inadvertently or some strategic move, maybe at concerned point in time, one might have thought that it may not be feasible to file appeal against the 5th ground. But for whatever reason, if you fail to file appeal on any of the ground, though it was part of the order of the assessing officer, then it is an additional ground which can be raised before the CIT appeal. It can be raised anytime as long as the appeal is not disposed of. And the only condition for the purpose of filing is that the CIT appeal should be satisfied that the omission was not willful or unreasonable. Various judgments and orders of tribunal indicate that the discretion should be exercised liberally, and ordinarily the additional ground should be permitted. Now, one more issue which may arise in the context of this additional ground is regarding limitation. As we know that for the purpose of filing appeal before CIT appeal, the appeal is required to be filed within 30 days of communication of the order of the assessing officer. Now, the question may arise that if the additional ground is raised subsequently after the expiry of limitation, then whether the provisions of limitation will apply to the additional ground raised subsequently. The law is settled now by various judgments, and Rajasthan High Court has taken a view that limitation applies only for the purpose of filing the appeal. Once the appeal is filed within the limitation, the additional ground can be taken up anytime as long as it is taken up before the appeal is finally heard. I am not giving all the citations. The judgment I referred to is 263 ITR 317 Rajasthan High Court. In the case of Shilpa Associates, I will provide the PDF of the PPT to Karthike, so that friends, you need not cite or note down the citations which I am providing. The necessary citations are provided to Karthike by way of a separate PPT. The next similar issue is regarding fresh claim before CIT appeal. Fresh claim is also as such an additional ground, but the difference between what we earlier cited as additional ground and additional ground by way of a fresh claim is that in the earlier case, the issue was raised and decided by the assessing officer. It was part of the assessment order, and only at the time of filing the appeal, it was omitted to be included in the ground of appeal. Whereas in the case of a fresh claim, the claim was not put across before the assessing officer, meaning thereby, even at the time of filing of return of income or even in the revised return if filed, the claim was not put across. Normally, once a claim is not put across in the return, original or revised, then it cannot be put across subsequently. However, there are some exceptions to the rule, and a fresh claim can be even put across before the CIT appeals, provided in 3 cases. First is that the material necessary for the purpose of adjudication are placed on record. Now, in this context, as the assessee's representative, one must ensure that at the time of assessment, one must try to put across or place on record all the documents which one can to the best of the efforts. Such exercise can help one at the time of appeal before CIT appeal if one finds that any claim which ought to have been made in the return or revised return and one has failed to put so, even then such claim can be put across before CIT appeal if necessary material is placed on record to permit the adjudication of such claim. The second exception is an alternative plea, meaning thereby, let us take up a case where an assessee can avail various deductions under section 80. Now, if the returned income, let us say, is only rupees 5 lakhs, and if you have 3 deductions available under section 80, if by claiming one of the 3 deductions, your returned income turns out to be 0 or nil, then you need not claim the remaining 2 deductions. Now, it may so happen that in the process of assessment, the claim of deduction which you made is disallowed, or for any other addition, the return income is increased. In such kind of cases where at the time of filing the return of income, the assessee was not required to or was not in a position to make a claim, and subsequently the claim was required to be made, in such case, the assessee can make a claim directly before the CIT appeals. The third and the final exception is regarding a jurisdictional ground. Am I audible?
Yes, perfect.
Yes, sir.
Yes, sir.
Yes.
Okay. The third and the final exception is regarding a jurisdictional ground. Let us take an example that if the assessment order is either time barred or notice under section 143 was not issued within the time limit, or the reassessment order is for any of the possible grounds is invalid. If such a claim was not put across before the assessing officer during the assessment stage, then such a claim, such a ground can be raised for the first time before CIT appeal or ITET. Any ground which is regarding the jurisdiction of the assessing officer can be raised at any time before any of the appellate authorities. In this context, Cochin Tribunal, in a case where deduction under section 80 HHC was not claimed, but the material necessary for the purpose of determining the claim were on record, has taken a view that such deduction can be claimed even during the appellate stage. Similarly, Hyderabad Tribunal also took a view that when deduction under section 10B was claimed and 10A was not claimed, but deduction under 10B was disallowed by the assessing officer, then the assessee can claim the deduction under section 10A for the first time directly before the CIT appeals. The third issue is regarding additional evidence. Now, the basic rule is that assessee or the appellant can file before the CIT appeals only those evidences which are filed before the assessing officer. So, at the time of filing the paper book of documents before the CIT appeals, one would observe that the paper book should contain a certificate that the documents which are placed in the paper book, all the documents were placed before the assessing officer. Now, the rule that any evidence only those evidences which were placed before the assessing officer are permitted before CIT appeal. The rule has an exception, or rather, I would say Rule 46A has 4 exceptions, whereby even the evidences which were not placed before the assessing officer are permitted to be placed on record before the CIT appeals. The 4 exceptions are: the first is when the assessing officer refuses to admit evidence which he ought to have admitted. The second is that the appellant was prevented by sufficient cause from producing any evidence, though he was called upon to produce by the assessing officer. Third, which is also similar, wherein the assessee was prevented by sufficient cause from producing evidence, though not called upon by the assessing officer, but it was relevant to any ground in appeal. And the fourth is that when order was passed by the assessing officer without giving sufficient opportunity to the appellant to produce necessary evidence on record. Now, Section 250, subsection 4 empowers the CIT appeal to call upon for production of any document or for examination of any witness. Now, for the purpose of the exercise of power by CIT appeals, the restriction under Rule 46A shall not apply. The restrictions are only applicable to the appellant filing additional evidences. But if CIT appeal suo motu believes that any evidence or a witness is necessary for efficient disposal of appeal, then the CIT appeal has the power to call upon such evidence or a witness. However, it is not a right of the appellant, the assessee, to ensure that CIT appeal calls upon the additional evidence by way of document or a witness. So if the CIT appeal suo motu is not satisfied that such evidence or witness is necessary, in such event, the appellant cannot, as a matter of right, claim that the CIT appeal should call upon such witness or evidence. For the purpose of producing additional evidence by the appellant, the procedure is this wise. The applicant or the appellant should file an application for the purpose of producing on record the additional evidences. The application should provide the reason for the failure, and it should ensure that one of the 4 exceptions carved out by Rule 46 are satisfied by the application. CIT appeal should, by speaking order, decide whether he is permitting or rejecting the additional evidences. If the additional evidences are admitted by CIT appeal, in that event, the CIT appeal should provide an opportunity to the assessing officer to counter the additional evidences. For example, if the evidences are documentary evidences, then AO should be permitted to also rebut by other documentary evidences or witnesses, or if the additional evidences is by way of a witness, in that event, the AO should be permitted to cross-examine the witness. It is a basic principle of law, as the evidences are normally of 2 types, documentary and oral evidences. Oral evidence would mean affidavits or statements of witnesses. For all the oral evidences to be admissible as evidence, it is a must that the other side, the aggrieved party, is provided an opportunity to cross-examine the witness. If such opportunity of cross-examination is not provided, then such oral evidence is not admissible. But if the opportunity is provided and the party fails to exercise the opportunity, then it is lost and the evidences are admissible. Now, this will take us to the next issue, which is regarding the various legal principles relevant in the appellate proceedings. Though as such, these principles are applicable to all the appellate proceedings, but we will focus in the context of CIT appeals. The first principle is principle of consistency. It is based on the principle of res judicata, which has its roots under the CPC. The principle of res judicata says that when the issues which are already adjudicated and settled, it should not be permitted to be raised again. Now, the principle is necessary for the purpose of bringing finality to any litigation or any issue. In the context of income tax, the principle of res judicata is not applicable strictly because each assessment year is an independent unit and its assessment is based on the specific facts of that particular year. So, as such, strictly the principle of res judicata does not apply to the income tax proceedings. However, the principle of consistency, which is an offshoot of the doctrine of res judicata, is applicable to the income tax proceedings. We have the lead judgment of Supreme Court in the case of Radhasamy Satsang, which takes a view that the principle of consistency should be applied in the proceedings under the Income Tax Act. The doctrine requires that if a view has been taken in earlier year, then the same view shall be followed even in the subsequent years unless there is a change in fact or circumstances. We have a judgment of Mumbai Tribunal wherein the facts were this wise, that the assessee was dealing in transactions in shares and the dispute was whether the transaction in shares would amount to trading. In that case, it will be taxed as business income, or it will amount to investment. In that case, the gain will be a capital gain. The case of the assessee would always be that it will be investment and should be taxed as capital gain, whereas the assessing officer would claim that it shall be taken up as business income and taxable at a higher rate of 30%. Now, in that, the facts of that case, in the earlier years, in similar transactions and similar facts, the assessing officer accepted the view or the case of the assessee to consider the transaction as investment. In the facts of that case, the tribunal took a view that since the facts are similar and consistent, and in absence of any change of facts or circumstances, the AO should not be permitted to take a different view and the transaction should be taxed as capital gains. The next principle is regarding judicial precedent. The principle says that whatever law or the principles which are articulated by a higher court should be followed by the lower courts. So, judgment of Supreme Court is binding to all courts in India. In absence of judgment of Supreme Court, the judgment of Jurisdictional High Court binds to all subordinate authorities within the state. Now, it may so happen that the Jurisdictional High Court in two different cases may take up two different views. In such cases, normally the later judgment should prevail. Normally, in such cases, the later judgment would distinguish the facts of the earlier case. Normally, the later would prevail, but in a given case, it may so happen that the facts of your case are similar to the facts of the earlier case and not the later case. In such cases, you can claim that even the judgment of earlier case should apply to your case. The lower authorities or the subordinate authorities cannot claim that the binding judgment should not be followed on any of the ground, including that the judgment was not decided correctly or some important law or fact was not brought to the notice of the jurisdictional High Court or Supreme Court. Now, in a given case or for a particular issue, if there is no judgment of a Supreme Court or a jurisdictional High Court, and if there is a judgment of a non-jurisdictional High Court, then how will the judgment of non-jurisdictional High Court bind the authorities within the state? Now, it will depend on two different situations. The first situation is a case where the judgment of non-jurisdictional High Court is the only judgment or there is no contra review. So let us take up a situation where Bombay High Court takes up a particular view and the CIT appeals or ITAT in Gujarat has to decide a particular issue. Then whether the judgment of Bombay High Court will bind the authorities within Gujarat, if it is the only judgment on the point, it should bind the authorities within Gujarat. But however, there is one exception to the rule. The exception is that if the judgment of the non-jurisdictional High Court is being taken without considering a statutory provision, and if that is so, then the judgment of non-jurisdictional High Court is per incurium, and so it is not binding to the authorities within the state. This contention of the judgment being per incurium is not available to judgment of jurisdictional High Court or Supreme Court. But if the judgment is of a non-jurisdictional High Court, then the subordinate authorities can take up a view that since it is per incurium, it shall not be followed. The second situation is where there are multiple High Courts taking a view and taking up contrary view. Let us say Bombay High Court takes a view in favor of the assessee and Karnataka High Court takes a view against the assessee. Then which of the two judgments will bind the authorities within Gujarat? There are diverse views regarding the issue. The first view is that in such kind of cases, the judgment which is favoring the assessee should be preferred over the judgment which is against the assessee. And some of the courts have taken a view that in such cases, the authorities are free to accept the judgment whichever they find appropriate. The Ahmedabad Tribunal in the case of Canal Oil 121 ITD 596 took a view that in such kind of cases, it is for the authorities concerned, the tribunal or the concerned authority, to decide that which of the non-jurisdictional High Court's judgment or this decision it should follow. The next principle is regarding doctrine of merger. It states that the judgment or decision of the lower forum should merge and absorbed by the judgment of the superior forum. However, it shall apply only to that part of the order which is challenged before the higher authorities. The principles of merger shall not apply if the appeal before the higher forum is dismissed for one, if it is dismissed for default on account of non-attendance or failure to cure a technical defect. Second is if the dismissal is for failure to implead the representatives of the deceased respondent. And third is the case where the appeal is dismissed as it being time barred because of the law of limitation. So only if the appeal is dismissed on account of one of the three grounds, in such cases, the appellate order will, or the lower court's order will not merge into the order of the higher forum. Now, for the purpose of deciding whether the order merges into the order of higher forum, one should consider the nature of jurisdiction of the higher forum and the subject matter of challenge before the higher forum. So let us take up an example regarding the subject matter of challenge. If CIT appeal has decided 4 issues in year number 1 and the assessee has preferred an appeal before the ITAT in the year number 1 only on 3 of the 4 issues. So the judgment of CIT appeal shall merge into the order of ITAT only regarding the 3 issues for which the appeal was preferred before the tribunal. Regarding the 4th issue for which the appeal was not preferred, the judgment of CIT appeal shall not merge into the judgment of the tribunal. The second issue for the purpose of determining merger is the nature of jurisdiction of the higher forum. The higher forum should have the authority and the jurisdiction to decide a particular issue arising from the order of the lower forum. So let us take up a case where the judgment of tribunal is being challenged before the High Court. Now, when the judgment of tribunal is put or is challenged before High Court by way of a tax appeal, only a substantial question of law can be raised before the High Court. So it may so happen that the High Court dismisses a particular ground of appeal as it fails to have a substantial question of law. If that happens, then the order of the Honorable Tribunal should not merge into the order of the Honorable High Court regarding the ground which is not adjudicated upon by the High Court. Similarly, it may so happen that the order of the Honorable High Court is challenged before the Honorable Supreme Court by way of SLP. And if the Supreme Court decides not to entertain the SLP and without converting the SLP into appeal, dismiss the SLP without giving any reason. If that be so, then the order of the Honorable High Court should not merge into the order of the Honorable Supreme Court. The next issue is regarding power of enhancement. The CIT appeal has the power in deciding an appeal against the order of assessment, either to confirm, reduce, enhance, or annul the assessment. Now, it may so happen that during the pendency of the appeal, the appellant, the assessee, would have preferred an application before the settlement commission, and for whatever reason, the settlement fails. And if the appeal before the CIT appeal is continued, if that be so, then any information regarding disclosure before the settlement commission and the material obtained during the inquiries, it shall be considered by the CIT appeal, and on the basis of such information and material, if the CIT appeal is empowered to enhance, it can also enhance the assessment. Now, the institution of CIT appeal, which is an appellate institution as such, but it is somewhat different as compared to ordinary court of appeal. The reason is that normally before any court of appeal, both sides or both parties are permitted to challenge the order by way of appeal. But before CIT appeal, the assessing officer or the revenue is not permitted to file appeal against the assessment order. And so as to take care of the interest of the revenue, the CIT appeal is empowered to enhance the assessment. Now, in a given case, it may so happen that a particular source of income the assessee would offer to tax under a particular head, and CIT appeals, though the assessing officer accepts the claim of the assessee, but CIT appeal takes up a view that it is required to be taxed under some other head, different head. If that be so, as long as the taxable income is not increased, such transfer of income from one head to another head will not amount to enhancement. However, the power of enhancement has some limitations as well as restrictions. The CIT appeals power of enhancement, as CIT appeal is not, at the end of the day, CIT appeal is an appellate authority and not assessing authority. So the CIT appeal cannot travel beyond the subject matter of assessment. That is, the jurisdiction of the CIT appeal is only on the issues of appeal and whatever is offered to tax in the return of income. So, meaning thereby, if a particular source of income is not offered for tax by the assessee in the return of income, and the assessing officer has also not discussed about the same said source of income in the assessment order, then the appellate authority, the CIT appeal, cannot tax a new source of income which is not disclosed in the return of income and not discussed in the assessment order. Now, in a case before Madras High Court, there were some entries in the books of accounts regarding a sum which was sought to be added by CIT appeals. But since the sum was not subjected to process of assessment, meaning thereby it was not disclosed in the return of income and not discussed in the assessment order. So accordingly, the Madras High Court took a view that it is a new source of income and CIT appeal is not permitted to tax or to enhance income by the said source of income. Now, enhancement in remand proceedings. Normally, the powers of CIT appeals in remand proceedings are same as if it is an original appellate proceedings. So, meaning thereby, normally the CIT appeal can exercise the power of enhancement even in the remand proceedings. However, if the remand is for a particular issue, or let us say the tribunal or high court remands the matter to the file of CIT appeal for the purpose of determining a particular issue, in such case, the powers of CIT appeal are limited only to for the purpose of determining the said issue, and in such case, enhancement is not permissible. But if the set aside of the appellate proceedings is by way of restoring the matter to the file of CIT appeal without any restrictions imposed or any condition in the order of a higher forum, in such cases, the CIT appeal has the power to enhance even in the remand proceedings. Enhancement at the instance of the assessing officer. The assessing officer can also point out to the CIT appeals that enhancement on a particular issue is required, and if the CIT appeal is otherwise empowered, then it can, by way of giving an opportunity to the assessee, consider enhancement of income. Power of annulment of assessment. Annulment would mean to hold that the assessment is void ab initio. There is a difference between setting aside the assessment and annulling the assessment. Setting aside the assessment would mean that the assessment is restored back to the file of the assessing officer, and the assessing officer can again frame the assessment order. If there is any particular irregularity, for example, if the assessee is not given opportunity to put across evidences or to cross-examine the witnesses for such irregularity which does not touches upon the jurisdiction, in such cases, normally the ideal or the right correct course of action is set aside. However, now the powers of set aside are taken away from CIT appeal, which will come to later. But in a given case where the CIT appeal holds that the assessing officer does not have the power to frame the assessment order, or the assessment is either time barred or for whatever reason it is beyond jurisdiction, then the CIT appeal can annul the assessment. Earlier, CIT appeal had the power to even set aside the assessment, but now it is withdrawn by the Finance Act 2001. The next issue is regarding appeals against agreed additions. It may so happen that the assessee may, after due consideration of the facts, decide to surrender a particular issue or agree to an addition. Normally, when the addition is on agreed basis, you cannot challenge the same by way of filing of an appeal before the CIT appeals. However, the assessee can successfully file appeal before CIT appeal even against an agreed addition if the surrender or the consent was under a mistaken belief or by misunderstanding or wrong interpretation of law. In such cases, if the appellant or the assessee can successfully prove the same before the CIT appeals, in such cases, agreed addition can also be challenged. Normally, the procedure, the appellant has the option either to file directly an appeal before CIT appeal or an application for rectification under section 154, stating all the facts which are necessary for the purpose of proving that the consent was under a mistaken belief. The ideal and preferred way is to first file an application for rectification under section 154 and thereafter, if required, file an appeal before the CIT appeals. The next issue is regarding stay of demand. Now, normally we know that we don't need to file, or we are not like, unless in the context of indirect tax, we are required to pay pre-deposit amount. In the context of income tax, there is no concept of pre-deposit, meaning thereby if the tax on the returned income is paid, in such cases, the appeal is maintainable before the CIT appeals. But merely because you have filed an appeal against the order of assessment before the CIT appeals, it does not automatically stay the demand notice or the operation of demand notice. Section 156, which deals with demand, requires the assessee to pay the tax under the demand notice within 30 days. However, now we have a circular which says that if 15 or 20% of the tax disputed is deposited, then automatically the demand will be stayed. But it may so happen that at times the assessee is not in a position to pay even the agreed amount of 15-20%. In such cases, the assessee, the appellant, has an option to file an application for stay of demand even without making such pre-deposits. The appellant has the option either to file an application under section 220 before the assessing officer, and the assessing officer has the discretion to treat the assessee as not being in default during the pendency of appeal. The assessing officer can also permit payment by way of installments. However, the appellant, the assessee, also has an option to file an application for stay directly before CIT appeal under section 251. Though normally the ideal or the best preferred way is to first file an application before the assessing officer and then before CIT appeals, so that you have two forums to raise your grievance as compared to directly raising the same before the CIT appeals. Now, for the purpose of deciding the issue of stay on demand, the CIT has a delicate task of balancing the case and deciding whether a prima facie case is made out, what is the financial condition of the appellant, and what are the safeguards to protect the interest of the revenue. The Kerala High Court has taken a view that the CIT appeal cannot say to the appellant that you cannot file an application for stay directly before CIT appeal. You are required to go before the assessing officer. Even if application for stay is preferred directly before CIT appeal, even then it is maintainable, and CIT appeal is required to adjudicate upon the application for stay. Now, at the time of filing of appeal, we are also required to, along with the details, we are also required to provide the statement of facts and grounds of appeal. The other details, which are more or less clerical and would not require much of application of mind, or rather they would not decide or will not impact the adjudication of appeal. But the two things which will impact the adjudication are statement of facts and the grounds of appeal. The statement of facts is an important ingredient of form number 35, which is memo of appeal. It also becomes a permanent record and plays an important role if the matter travels to the ITAT High Court or Supreme Court. Statement of facts is not required to be filed before the Tribunal, High Court or Supreme Court. It is required to be filed only before the CIT appeals. And so it clearly indicates the importance of placing on record the material facts, because that is the only opportunity one gets to place material facts before an appellate forum. Though the concept of statement of fact is neither defined nor mentioned anywhere either in the Act or rules, but it is taken up from Order 6 of CPC, which is pleadings generally. Order 6 states that every pleading shall contain only a statement in concise form of material facts, and it should not contain the evidences by which they are required to be proved. Every pleading shall be divided into paragraphs numbered consecutively, with each allegation, that is addition or disallowance, being taken up by way of a separate paragraph. Statement of facts is a mandatory requirement of form number 35. An appeal not containing statement of fact can be treated by the CIT appeal as a defective appeal, and after issuing a notice to cure the defect, if the appellant fails to cure within the time limit, then the appeal can also be dismissed on the ground of defect. Statement of fact should not contain arguments. It should be clear, crisp, and concise. If you are filing the appeal online, then normally it cannot exceed 10,000 words. But you can overcome this restriction by way of filing a separate sheet along with your appeal. Though there is no defined format of statement of facts, normally the following points must be taken up or must be kept in mind while drafting the statement of facts. It should be comprehensive and complete. All material facts should be conveyed. It should be clear, specific, unambiguous. It is also an opportunity to bring additional facts on record if the same could not be brought before the assessing officer. It can also help your case for the purpose of filing additional evidence. The Rule 46 requires you to prove that you were prevented by sufficient cause from filing the evidence before the assessing officer. To make out a good case under Rule 46 for additional evidence, you must put across necessary facts in the statement of facts. It should be divided into proper paragraph, structured properly, and state the facts as far as possible in chronological order. Along with statement of facts, there is one more element in the appeal, which is the heart of the appeal, and that is grounds of appeal. The grounds of appeal shall lay down both the factual reason and the legal arguments, the legal contentions, not the arguments, the contentions. Though there is no standard guidelines or rules for the purpose of drafting grounds of appeal, however, commonly accepted practices for the purpose of drafting grounds of appeal are: first point, all the grievances or controversy should be included. Sometimes it may so happen that for a particular ground, which is an addition or a disallowance, if you believe that the chances of success are less, either because of the current interpretation of law being not so favorable or the factual weakness of the case. Even in such cases, one should take up even such grounds in the ground of appeal, because it may so happen that at the time of adjudication of appeal, the interpretation may have varied. As law is continuously evolving, so the interpretation of law at the time of filing of appeal and the time of adjudication may vary. So you must take your chance and file appeal against all grounds, irrespective of the merits of the ground. Ground should be comprehensive but simple, concise, and specific. As under the electronic format, each ground cannot exceed 4,000 words. Again, you can file a separate sheet to overcome the restriction. The ground should be brief, but it should not have arguments. The argument should be taken up normally by way of written submissions, but the grounds of appeal should not include the arguments. The language used should be firm but polite. Grounds must be serially numbered with separate ground for each grievance. Avoid referring to case laws while drafting grounds of appeal. Normally, case laws, the interpretation vary from time to time. So it may so happen that the case law on which you are relying at the time of drafting the appeal may not be relevant or the right law at the time of adjudication of appeal. So case laws should be avoided. The structure of grounds of appeal should be this wise. The first grounds of appeal should be regarding the jurisdiction or the validity of the assessment. If at all such ground is to be taken up, it should be taken up first. Thereafter, the grounds regarding the point of law, followed by the ground regarding facts. And the last ground normally should be a residuary ground. It should say that the appellant should reserve his right to add, delete, modify, alter, or even substitute a ground of appeal. Alternative ground. What are alternative grounds? The grounds which, if you have taken up a ground of appeal, and if you believe that if you succeed in that ground of appeal, then another ground of appeal is not required to be taken up. But at the time of drafting the appeal, you cannot predict whether you will succeed or you will not succeed. So even those grounds which are required to be taken up only in the event if the if you fail to succeed in the main ground are the alternative grounds. You at the time of drafting the appeal should take up such alternative grounds because you cannot predict whether you will succeed or not. For example, if there is a disallowance under section 14A, of course the first ground is that the disallowance under 14A or 14A is not applicable to the facts of your case, and accordingly there should be no disallowance at all. However, you may alternatively take up a ground that if at all section 14A is applicable, then the disallowance made by the assessing officer is excessive, and accordingly appropriate disallowance should be made. Normally, the alternative ground should have a suffix that it is without prejudice to the rights of the main ground. Now, at the time of challenging the additions or disallowance, we at times make this mistake of not challenging the errors in calculation in the computation of tax liability. After the completion of discussion in the assessment order, there is a table which computes the tax liability. For it may have some error. For example, the rate of tax. The rate of tax is not appropriately stated in the computation sheet. All such grounds are also to be taken up. At times, they are being omitted inadvertently because our focus normally is on the discussion or the grounds which are discussed in the assessment order. But after taking up the grounds discussed in the assessment order, this miscellaneous ground should also be taken up and should not be ignored. The grounds of appeal should be short and it should not be argumentative. For example, I have drafted one ground of appeal as an illustration. If you are challenging a traveling expenditure, which is disallowed on the ground of your failure to substantiate it for wholly and exclusively for the purpose of business, the learned assessing officer add in disallowing traveling expenditure of rupees 1 lakh. The learned assessing officer failed to appreciate that the appellant had substantiated that the expenditure was wholly for the purpose of business. Any further contentions and arguments should not be part of the grounds of appeal. You may take up at the time of written submissions, but you should not make the grounds of appeal argumentative. This is all from my side now. I would like to take up questions from
Sridhar bhai, question. Someone has raised the hand.
right, the chat box. Somebody is Mr. Prakash Patel says CIT appeal powers are coterminous with the assessing officer. That is correct. The powers are coterminous with the assessing officer, and so it can make the assessment. and accordingly it can enhance the assessment. But for the purpose of enhancement, there is some difference in power. If the assessing officer has failed to tax a particular source of income which is not disclosed in the return of income, and there is no discussion in the assessment order, in such cases enhancement of that source of income is not permissible. But thereapart, the powers are coterminous.
સીધાભાઈ તમારો મ્યુટ છે, મ્યુટ છે.
Yes. Raghubai, તમને right આપ્યો છે. Ask your question, please.
હારી જોઈ ખરાબ કોઈ નથી.
એક બીજી વાત કરે છે. I am removing the permission. If anyone having question, please raise hand or write in the chat box. Sir, એક burning question છે. હમણાં CIT અપીલના orders આવતા નથી પેનલ્ટી સિવાયના. એના વિશે કંઈક તમે
હવે એમાં એવું છે કે see the time limit which are imposed upon them are not mandatory. It is directory. So you have no option. You that grievance cannot be raised before any forum. We
Sir,
have no option but to wait.
They keep sending the same questionnaire again and again. Sometimes even annexure is not there. And what should be the compliance strategy with such repetitive notices?
Highly, you can state in your reply that the earlier notice does not contain the annexure. Kindly provide the annexure. So, but see, ultimately, if your point is that if the adjudication process is not moving ahead, in that context, you have no right. You can't do anything about it. You just have to wait for them to adjudicate.
Mr. Amit Oza, you can ask a question by unmuting your mic. Amit bhai, mic unmute karo, તમે question પૂછી શકો છો. Though you have written in what about appeals heard in old regime matter remanded back to AO for verification, yet orders not passed.
જે હિયરિંગો થઈ ચૂકી છે, મેટરો રિમાન્ડ બેક થઈ તેઓને એની સામે રિજોઇન્ડર્સ બી અપાઈ ચૂકેલા છે, રિમાન્ડ રિપોર્ટ બી થઈ ચૂકેલા છે અને ઓર્ડરો આજે પણ નથી થયા.
Highly, a remind ma but they have time limit to pass orders. Section 253 ma time limits are imposed. If they fail to pass orders within the time limits, then if the orders are subsequently passed, as and when the orders are passed, you can challenge the same by way of appeal and claim that the orders are time barred. As long as
that means that CIT appeal no order jo time bar thai jaye to that
CIT
to be allowed.
CIT appeal mein koi time limit nathi. Assessing officer ne time limit. CIT appeal koi appellate authority
એમાં કેવું થાય છે સાહેબ કે અત્યારે જે ફેસલેસ રેજીમ ની પહેલાની વાત કરીએ તો જે સબમિશનો અપાઈ ચૂક્યા હતા જેમાં એઓએ રિમાન્ડ રિપોર્ટ બનાવ્યો તો ડિટેલની અંદર એસએસસી ની ફેવરના હતા એવા અને એઓએ ફિઝિકલમાં સબમિટ કર્યા હતા કન્સર્ન જ્યુડિશિયલ CIT અપીલ્સને. અત્યારે આપણે ફોલોઅપ લેવા જઈએ છીએ કેસનો તો એઓ બી ચેન્જ થઈ ગયા છે, જ્યુરિસડિક્શન ચેન્જ થઈ ગયા છે અને કોઈ CIT અપીલ્સ પણ ચેન્જ થઈ ગયા છે. એટલે જે ફિઝિકલ રિમાન્ડ રિપોર્ટો હતા એ અપલોડ થયા જ નથી અને આપણા લોગિનની અંદર પણ દેખાતા નથી.
જો રિમાન્ડ રિપોર્ટ તમને બરાબર તમને મળ્યા ના હોય સપોઝ upload thaya ke nahi is not so material so as long as you are not provided a copy thereof.
Exactly.
Then wherever your proceedings are pending either before the assessing officer or CIT appeal, you can in writing intimate them that sir I am not provided a copy of the remand report, kindly provide a copy. And even thereafter if they fail to provide and pass order, and in the order if they consider the observations in the remand report which are against you, then you can file an appeal that there is a breach of principle of natural justice.
સમજી ગયો સર. એક ક્વેરી બીજી એ હતી કે જે કેસમાં રિમાન્ડ રિપોર્ટ થયો કે નહીં આપણને ખબર નથી. મેટર રિમાન્ડ બેક થઈ હતી 2019-20માં અને આપણે કન્સર્ન એસેસિંગ ઓફિસર પાસે હિયરિંગ કર્યા હતા અને એમને સબમિશન પણ આપ્યા હતા પણ એમને રિમાન્ડ રિપોર્ટ કરીને CIT appeal ને આપ્યો કે નહીં આપ્યો ખબર હતી ને લોકડાઉન આવી ગયું હતું.
તો જ્યાં પણ તમારી અપીલ પેન્ડિંગ હોય CIT અપીલમાં કે ત્યાં તમે યુ ઇન્ટિમેટ ધેમ ધેટ આના પછી we are not provided a copy of the remand report. Kindly provide if at all, or kindly also update us about the status of the remand proceedings. એટલે they will update you, and also if at all there is a remand report available with them, they will provide the report. અને ત્યાર પછી પણ જો ના કરે તો again you can claim breach of principles of natural justice in the appeal.
Sure. Thank you.
પણ ટાઈમ લિમિટમાં તો જો appellate authorities are not having any time limit. એટલે એમાં your grievances have no answer. You just have to keep waiting. Assessing officers માં time limit છે, and if at all they do not adhere to the time limit, and if they do not pass any order, so I don't think you should have a grievance, because then there is no liability upon your shoulders. Only when the assessing officer passes the assessment order, there is a demand notice and you are required to pay. As and when that happens, if it is beyond the limitation, you can by way of appeal claim that it is beyond limitation, so the assessment order should be set aside or quashed.
We are not having anything in chat box, and
You can proceed for the certificate of appreciation procedure and vote of thanks.
Sir, kindly accept this certificate of appreciation.
Thank you, Jaimin bhai. It was excellent.
Yes, for enlightening us on these appeal subject.
Thank you so much, AGFTC and Karthike. Karthike have been very persistent and have been very motivating. And because of Karthike's motivation, after some time, I've been able to take up this opportunity. So I again thank the AGFTC and Karthike. Thank you so much.
Thank you so much, sir. And sir has already given us his PPT in advance, so we will circulate.
Yes, we'll circulate the PPT. Yes. Now proceeding for vote of thanks, I would like to thank today's eminent speaker, Advocate Jaimin Gandhi, for sharing his views and guiding us on the practical part of the proceedings before CIT appeal. We thank AGFTC and IT Bar and all the associations for joining hands for enhancing knowledge of the members. So thank you, and we thank all the attendees who attended today's webinar. These webinars are available on YouTube channel of AGFTC, so in future also you can refer to it. And today's webinar we are sure that so many people will refer in future because it contains so much of the knowledge part. Also, as an announcement, we are still having one webinar in pipeline on 7th, which is on RERA, as per the AGFTC and IT Bar's initiative to bring the new professionals, speakers on the platform, as well as touching allied laws apart from direct and indirect taxes. We have arranged that webinar. So my request is to everyone to join this and also spread the word. So anyone, see, knowledge is power in today's era, and anyone, whether member of our association or not, but if they are benefited with the knowledge, we are okay with it. So please spread the words. Maximum people can take benefit of the same. Thank you.
And Jaimin bhai, after hearing you about the CIT appeals, now we are rest assured, and we can definitely file without hesitation any appeal in CIT appeals. So it was fantastic, and you have powered us with your knowledge.
Thank you so much for the appreciation and the opportunity. Thank you.
Thank you.
With this,